Sometimes in the healthcare M&A market, one of the most frustrating things in getting a deal done is getting through all the legal and regulatory hurdles that are involved that can take weeks, maybe months. But if you don't want to have to spend weeks and months trying to get a deal done, there are attorneys you can hire who can take care of it, who specialize in these transactions and all the regulatory problems that people face. So I'm here today with Hedy Rubinger. She is a partner in charge of the healthcare practice at Arnall Golden Gregory in Atlanta, and she obviously is an expert in getting deals done. So that's that's your thing. I mean, people hire you. They want to get the transactions done. They need you to you understand state by state where the problems are, what the issues are. How do you structure a deal so that you can minimize the regulatory review and the timing to get it all closed?
So that's a great question. So the first thing we do is we look at the various states in which the provider, so if it's skilled nursing, we look at the states in which the provider is operating, and we look and see what sort of CON requirements there are, what the licensure requirements are, Medicaid requirements, and we basically look at those first, and each of those within a state has a different timetable. So the goal really is to get to the finish line at the same time in the various states. So depending on the state, we may recommend that the transaction be structured as a change of control as opposed to a CHOW, where a new legal entity becomes the actual provider and new provider agreements are obtained. So we really just, it varies from state to state. We look at it as a whole, and then we make a recommendation.
And you've done so many of these, probably in certainly all the active states. I mean, you know exactly what to look for and where the roadblocks are going to be, so ahead of time.
Exactly. So we try to stay ahead of it and keep up with what's happening with our various contacts in the states, and so we really work hard to keep ahead of it, and then really sort of manage our clients' expectations and really help them through the process.
Mm-hmm. And I know historically most of your work has been in the skilled nursing side, but are there any regulatory issues or special concerns for assisted living transactions that have been cropping up lately?
Absolutely. So we've been doing quite a bit of work in the full continuum of post-acute providers, and with respect to assisted living, our clients that are much more accustomed to nursing home sometimes are surprised by different requirements, and they think that perhaps because it's assisted living that the process might be easier, but within a given state the process might even be more time consuming and more burdensome for assisted living. So examples might be fingerprint checks that are required, and oftentimes investors are in another state and they are surprised to learn they actually have to visit the state and be fingerprinted in person depending on the state. Actually, Georgia's an example of that.
Where the principals on
the principals actually
entity
have to, yes. Policies and procedures have to be vetted ahead of time. Pre-transaction closed surveys have to be conducted in certain states for AL, and everything has to be in compliance. That can hold up transactions. So we just try to get all those issues going as quickly as possible, so that we don't have surprises at the end where a survey is delaying a whole multi-state transaction.
God, I wouldn't even think there'd be those kinds of issues on the assisted living side. And are you seeing more licensure categories in states for assisted living that you have to deal with?
We are. So, as the continuum of care is evolving, what we're seeing now, of course, is in skilled nursing facilities, we're seeing higher acuity residents. And then AL and memory care, we're seeing actually a need for almost an interim type of category, and so several states have been implementing new statutes and regulations really to allow certain AL residents to age in place and stay longer. So we're seeing that, and our clients are really getting their arms around those different categories.
And when regulatory approvals, for whatever reason, seem to be hard to come by or are going to take longer, how do you structure How do you structure with as a management agreement to kind of get around that temporarily?
Right, so the management agreement concept is used fairly often. So when everybody's ready to close the transaction, but for whatever reason, either not all of the regulatory approvals have been obtained or something else is delaying the transaction, then the purchasers will put a management agreement into place and will begin, and it really depends on the state. So the first thing I need to caution is that you look at the state and see whether it's allowed and what the parameters are. But assuming that a management agreement is allowed in a given state, then some of the economics of the transaction can start changing hands basically before the deal actually closes.
How about the regulatory issues, because a lot of times people are just buying, or entities are just buying a real estate, whether it's a REIT or a private investor. Are there different regulatory hurdles for just the real estate purchaser?
So the real estate purchaser, the biggest hurdle that they have is certificate of need. So what they want to do is make sure that if they're in a CON state and it's a CON covered service, that is really covered off on, and it's very clear who holds the CON at the end of the day. And then what we are also doing for our real estate only acquisition clients is a good bit of diligence, however, because even if it's just a sale leaseback, our clients really want to know a little bit more about the operating history of their tenant. So we're doing more and more regulatory diligence for these clients.
In the last few years, and we don't know how long this will continue, but there's been an uptick in the so-called RIDEA transactions. Are there any special or different regulatory issues involved with RIDEA deals?
So, well, with RIDEA deals, we're really sort of layering regulatory with tax, and so we work hand in hand with the tax council to make sure that the transactions, RIDEA compliant. But it's interesting because our clients that are historically only just landlords actually become the license holders. And so it's a whole new world for them. And so oftentimes it's the first time they've actually applied for a license. Many times that's the case. So we have to work through that process.
Does that, have you had an experience where that process kind of killed the RIDEA structure and they said, nah, we're just doing a straight sale leaseback kind of a thing?
Sometimes it can be an intimidating process, so yes.
And then for buyers, obviously there's all the regulatory problems, but what do you counsel them on things like non-regulatory things like an audit or investigations or criminal background checks, all that kind of stuff? What are the big issues?
Yeah, so right now we're at a time where so many of our clients are under some sort of investigation, audit. We're just at a time in the industry where there's just a lot of scrutiny. So really, because there's so much government scrutiny on our clients and on entities that our clients are going to purchase, so we really just recommend a thorough diligence, so that a very detailed diligence process, just where at least the questions are asked, so that our clients aren't surprised at the end of the day that they've just acquired an entity that's got some problems that they weren't aware of.
Right. And unfortunately, sometimes, there's one assisted living company bought a hospice company and didn't find out until 6 months later that there were all sorts of issues, but maybe no one else knew that at the time of the acquisition. There's not much you can do with that, but
right.
Now we have finally, the Affordable Care Act is the implementation is beginning. Most of your work has been, really, clients buying nursing homes, buying assisted living communities, buying the companies. But now, as the ACA gets implemented, we're going to see a lot more integration. How is that when your clients it's not just a nursing home, it's nursing home, home health, hospice, all these things and these contracts, accountable care organizations. How's that going to impact your job?
Well, we're already starting, it makes it more complicated,
yeah. More interesting.
Yeah, exactly. And we need to, structure around the federal and state anti-kickback laws, and we, make sure that those are reviewed. But yeah, we're just seeing many more transactions where a traditional nursing home only company is now acquiring other lines of service so that it can offer a full continuum.
Okay, good.
Yeah.
Well, I think given my forecast for 2013, it's going to be at least a number of transactions, not dollars. It's going to be a record year, and it seems to be going strong into 2014. So I think you're going to be a very busy attorney.
Thanks. Yeah, thanks. I enjoyed talking to you.
All right. Well, good luck, and enjoyed our chat.